citizens of the United States have certain rights. For example, we have the right to vote, we have the right to worship as we would like, we have the right to free speech. These rights are all guaranteed by the Constitution of the United States as well as the Bill of Rights. Healthcare consumers as well have certain rights that enable them to receive the highest quality of care possible. Hi, I'm Kathy Getrust, and I'm an instructor in community health, and today we're going to be talking about client rights. Anybody entering the healthcare system will receive a copy of a rights document. The particular form varies depending on the kind of institution that they access, and I will talk about several different kinds. The first is one called the resident rights. This is a document that is provided to anyone that's entering a skilled facility such as a nursing home. These rights were legislated by the federal government by the Omnibus Reconciliation Act of 1987, also called OBRA. The resident on admission to a nursing home must sign the document that they understand and have received their rights document, this resident rights. In addition, if a person enters into a hospital situation, they are given what's called a patient Bill of Rights. This was developed by the American Hospital Association and again is given to any person upon admission. And if the individual is unable to comprehend the form, whatever kind of document, rights document is received, then the family receives the information about the rights that the individual has during their health care stay. A third kind of rights document is called the client rights. This is a particular rights document that's used for any individual that's going to be receiving home health treatment. Regardless of the kind of rights document that might be seen, all healthcare workers have responsibilities relative to these patient rights. First of all, it's a professional nurse's responsibility or other designated individual to see that on admission to the healthcare facility, the individual has received a copy of the rights that's appropriate to that setting. All of us working in a healthcare setting must be knowledgeable about the rights document that is utilized in our facility, and if you are not provided a copy of that on your orientation to your new facility, please ask to see it and become very familiar with what it has to say. Supporting the rights of healthcare consumers contributes to effective patient care. Just as your employer may not discriminate in hiring practices, you may not discriminate, nor can I or any others, in the services and care that's provided to residents with vastly different backgrounds. Some may have different ethnic backgrounds, such as Asian American, African American, Hispanic, those that have different religious backgrounds, as well as those with varying economic backgrounds. Regardless of whether a patient is wealthy or if they're receiving public or state assistance, they must all receive equally quality care. Violation of patient rights is punishable by law, so all the rights of individuals must be adhered to. I'm going to be providing an overview of certain rights that are common to any of the rights documents, regardless of whether the patient might be admitted to a nursing home, to a hospital, or to a home health agency. But just remember that this is only a sampling of the rights, and it's your responsibility to become familiar with the particular rights documents that's used in your setting. The first is probably the cornerstone of all the rights, and that is the right to be treated with dignity, respect, and full recognition of one's individuality. That means that we need to respect all cultures and nationalities, and we need to be respectful of them as an individual. It would certainly be inappropriate to be demeaning to an individual, to talk down to someone, make fun of their disoriented status. We also, in a past experience, I worked in a long-term care facility where the caregivers enjoyed dressing the patients up. And there's nothing wrong with having residents look their finest, but it got to be a competition whereby some caregivers were overextending, probably crossing the line as far as what was appropriate. There was an excessive amount of makeup that was put on the individuals, gaudy jewelry, and by the time they were finished, some of the residents looked rather clownish in appearance, and so that certainly would not have shown respect for their dignity and needed to be stopped. Another right is the right to be treated, the right to privacy. That means that any treatments or care of personal needs to be done in a private area. That means the curtain needs to be pulled around their bed. That means bath blanket needs to be used for bathing, that the bathroom door needs to be closed when the patient is using it. Privacy also in phone conversation. If a resident receives a phone call, it's your responsibility to excuse yourself so that individual can carry on a conversation in private. Also, the important thing is knocking before entering a patient room. Most of the time I see people knocking, but they're knocking on the door as they're entering, as opposed to knocking, pausing, and waiting for the individual to maybe cover themselves up or whatever might be needed before entering. Think about how you would feel in your home setting if someone knocked on your door or rang your doorbell, and as they were doing so, they were also entering your home. I think that we would find that highly inappropriate and an invasion of privacy, and so too it is for our residents. Confidentiality is another right. Information seen on records and heard about patients is considered privileged information, and this is information that the patient's spouse and family members even may not be aware of. Confidentiality must be kept, and so never discuss anything with anyone other than on a need-to-know basis, and generally that's the individuals on the care team. With privilege comes responsibility, and so it's important not to discuss anything outside of that core team. That means no discussion in the hallways of patients' cares or their names, no discussion in the elevator about specific patients, in the break room, cafeteria, or in your home setting. The United States Congress and the United States Department of Health and Human Services have developed national standards to protect patients' personal medical records. Gone are the days when our family physician kept our records sealed away in a locked cabinet someplace. As we all know, patient information is now electronically accessed and exchanged quickly. These new standards developed by the government are provided by HIPAA, H-I-P-A-A. That stands for the Health Insurance Portability and Accountability Act. And it provides protection not only for paper, but oral and electronic information, which creates a privacy system that covers all personal health information and other medical records in any healthcare facility that a patient might be found in. Another right is the right to participate in planning their own cares. That means a person has a right to choose physician or caregiver. If an individual does not want a particular caregiver taking care of them, that's their right to refuse to have that. They have a right to choose the clothes that they want to wear in a healthcare setting, when they get up and when they go to bed, and certainly any change in healthcare status. They also have the right to refuse cares and treatment. Let's just say an individual decides they don't want to go down to the dining room, and that's practice for most individuals in a long-term care setting. Certainly it would be appropriate to ask the individual how come, but if they refuse, certainly their tray can be taken to their room for them to eat. Sometimes, however, it might just be that the individual is feeling a little bit shaky and unsteady and would welcome going to the dining room provided that they had an arm of a caregiver or a wheelchair. So be sure to ask as well. Also, they can refuse end-of-life decisions. Many times they can refuse CPR. Individuals can refuse artificial breathing or medications other than pain meds at the end of life. The last that I'll talk about is the right to voice and file grievances. Grievances also known as complaints. That might be complaints about anyone or anything in a healthcare setting. Many facilities utilize the services of an ombudsman. An ombudsman is an impartial individual who investigates complaints and acts as an advocate for the patient and family. This ombudsman is provided with the individual's medical records, any other information, as well as the resident, in order to seek facts related to the complaint. Also, the resident has the right to voice any grievance without fear of retaliation or that something bad could happen to them as the result of their doing so. In 1998, the state of Wisconsin passed what's called the Wisconsin Caregiver Law. This law protects citizens from caregiver misconduct. I would like you now, please, to watch a videotape that's been graciously provided by the Department of Health and Family Service as it talks about the Wisconsin Caregiver Program.
Whether your workday starts in the morning, afternoon, or evening, chances are it's often hectic and stressful. Maybe it's getting the kids to school on time, or caring for a sick relative at home. Stress is a fact of life. You understand that because your job offers its own stressful situations. Providing care to others is an important and rewarding role. Whether you are providing care in a community-based residential treatment facility, a nursing home, a hospital, a client's home, or any other adult health care facility, you are important to the emotional and physical well-being of those entrusted to you. No one knows better than you the challenges you face while carrying out that trust. Some days you may feel as if you have too many duties and too little time to respond. In the face of on and off-the-job stresses, your ability to serve some of our most vulnerable clients depends on your ability to remain calm. You need to remain focused and aware of your behavior and the behavior of other caregivers to ensure safe and compassionate quality care. The state of Wisconsin, to help ensure that our most vulnerable citizens receive the ultimate in safe and compassionate care, passed the Wisconsin Caregiver Law in October of 1998. The Caregiver Law requires many healthcare facilities to report incidents of caregiver misconduct and some injuries of unknown source to the Department of Health and Family Services. Today, we're going to look into several aspects of the Wisconsin Caregiver Program. Understanding the Caregiver Program can protect those you serve and prevent caregiver misconduct from occurring. First, we want to define some terms. How does the Wisconsin Caregiver Program define caregiver misconduct? What is an injury of unknown source? Next, we will review some case examples and discuss what you saw and heard. Are these examples of caregiver misconduct? Finally, we will explore why it is important for you to immediately report to a person in authority any injury or any incident that could result in client injury or distress, and what happens after you report an incident at your workplace. After reviewing the definitions, the case examples, and considering the benefits of reporting, you will have a clearer idea of how the Wisconsin Caregiver Program will protect you, your coworkers, and your clients. First, let's look at what we mean by caregiver misconduct. An act of caregiver misconduct may fall into one of three categories: abuse of a client, neglect of a client, or misappropriation of a client's property. Abuse is defined as an act that contradicts a healthcare facility's policy and procedures and is intended to cause harm. Now, the harm or intended harm may be physical, mental, or emotional, and it may result in pain, injury, or even death. Some examples of abuse include sexual harassment or inappropriate touching of a client, hitting, slapping, pinching, and kicking a client. Abuse also includes acts that intend to threaten, intimidate, or frighten. The key to abuse is that the caregiver intended physical, mental, or emotional harm. Next, let's look at the second category of caregiver misconduct. Neglect is defined as the intentional carelessness, negligence, or disregard of policy or care plan which causes or could be reasonably expected to cause pain, injury, or death. The results of neglect may be very similar to those of abuse. The major difference between abuse and neglect is that in the case of abuse, harm was intended. In neglect, the caregiver does not intend to harm the client. However, in the case of neglect, the caregiver's actions were completed on purpose in a careless or negligent way. Again, neglect goes beyond obvious physical neglect to include disregard for clients' rights. Neglect may cause mental or emotional damage that results in anxiety, fear, depression, withdrawal, or any number of similar behaviors. Remember, an incident becomes a case of neglect when the caregiver has behaved in a careless or negligent manner that could be expected to cause harm, even though the caregiver never intended to harm the client. Let's look at the third category of caregiver misconduct: misappropriation of client's property. The common word for misappropriation is theft. Misappropriation includes actions such as theft of a client's money, credit cards, or jewelry, or misuse of personal property, such as using a client's phone or other personal property without consent. Use of a client's identification or property for personal gain can be considered misappropriation. Finally, an injury of unknown source is defined as an injury that occurs to a client where the source is not immediately apparent when the injury is discovered. A high percentage of injuries of unknown source, once investigated, are found to be incidents of caregiver misconduct. Keeping the three categories of caregiver misconduct in mind, look at the upcoming case examples. Are you witnessing acts of abuse, neglect, or misappropriation, or an injury of unknown source? Even if the actions shown in these situations wouldn't be considered acts of caregiver misconduct, are there steps that could have been taken to prevent them, or other ways to respond? After each segment, the tape will be stopped so you can discuss what you observed. Case example 1. A client's care plan clearly states that any assisted lift is to be carried out by 2 caregivers. It's been a particularly hectic shift, and no one else appears to be available to help. The client needs to be moved. The caregiver is alone and has often executed such a lift single-handedly. It's no big deal. However, in the course of the move, the client shifts her weight. The caregiver loses her balance, and the client falls. The fall results in the client breaking a hip. Is this a case of abuse or neglect, or neither? How could this have been avoided? Case example 2. An Alzheimer's patient has been continuously pushing the call light. Each time the staff person on duty responds, there appears to be nothing wrong. Finally, exasperated, the staff person disconnects the call light and returns to other duties. Is this any form of caregiver misconduct? Are there other options? Case example 3. While providing home care to a client, a caregiver has occasionally needed to make long-distance personal phone calls. After a number of visits, the caregiver finds that the client usually requires up to a half hour in the bathroom. No assistance is needed during this time. This seems like a convenient time to take care of long-distance personal calls without the client's permission or knowledge. The caregiver uses the client's phone but always breaks off the conversation at once if the client calls for assistance. What do you have to say about this situation? Case example 4. A caregiver overhears a nurse aide coworker shout loudly to a resident, "Will you shut up? I am sick and tired of cleaning up your disgusting messes. You make me sick." The caregiver hears the resident begin to cry. Later that day, the caregiver notices that the resident, who is usually very outgoing and has a great appetite, just picks at her food and speaks to no one. What is going on here? What course of action, if any, would you suggest the caregiver who overheard the incident take? Case example 5. In this last segment, an alert client complains to a caregiver of a constant pain in her left arm. The caregiver says she probably slept on it and leaves her alone in the room. The next day, the client is crying with pain, so the caregiver reports the status of the client to the shift supervisor. An X-ray is taken and reveals a fracture. What could the caregiver have done differently? Could this be caregiver misconduct? All staff persons having contact with clients, and I mean everyone, must report incidents of suspected caregiver misconduct or injuries of unknown source to a person of authority in their health care facility. It is then the facility's responsibility to decide how to proceed. Sometimes an incident resulting in physical, mental, or emotional harm or misappropriation of client property is clearly the result of an action between caregiver and client, caregiver misconduct. At other times, physical or emotional hurt is evident, but the cause of the hurt is unknown. In the 5th case, for example, there was indeed an injury, a broken arm. However, the cause was unknown. Injuries of unknown source must also be reported to your supervisor. Healthcare facilities are required to report injuries of unknown source to the Department of Health and Family Services. The number of injuries of unknown source can be greatly reduced with prompt, careful reporting by caregivers. Let's say that in the course of a normal daily activity, an incident occurs that could later result in a bruise or other injury. A resident stumbles into a door frame. No abuse, no neglect, it is simply an accident. If a caregiver has witnessed the accident, checked on the condition of the client, and reported the event to a supervisor, there will be no injury of unknown source the next day. The health care facility will not be required to report the incident to the department because they have documented that the injury was not due to caregiver misconduct. The health care facility must investigate to try to determine if caregiver misconduct has occurred. They may ask for assistance from an outside resource, such as law enforcement. When a health care facility's investigation of an incident results in a clear case of caregiver misconduct, that incident must be reported to the Wisconsin Department of Health and Family Services, Bureau of Quality Assurance, BQA. The healthcare facility must also report an incident to BQA if, after their internal investigation, they are still not 100% certain that caregiver misconduct did not occur. Once an incident is reported to the Bureau of Quality Assurance, BQA reviews the report to determine if a follow-up investigation will be completed. If the Bureau does decide to investigate, a notice will be sent to the caregiver and the facility. If the department determines that there is sufficient evidence to show that caregiver misconduct occurred, then the caregiver will receive a notice that the substantiated finding will be entered on the Wisconsin Caregiver Registry. The caregiver has the right to appeal this decision. If a substantiated finding is entered on the Wisconsin Caregiver Registry, the caregiver is banned from working in facilities regulated by the Bureau of Quality Assurance, unless approved under the rehabilitation review process. In addition, federal regulations permanently ban nurse aides with a finding of caregiver misconduct on the Caregiver Registry from working in federally certified nursing homes or federally certified intermediate care facilities for persons with mental retardation. Providing quality, safe, and compassionate care to our most vulnerable citizens is a responsibility with great challenges and great rewards. You live with that responsibility, those challenges, and those rewards every day you walk through the door. Taking care of yourself as a caregiver, taking a moment to focus, and taking time to reflect will help you continue to provide the fine healthcare service Wisconsin citizens know they can expect.